Hi guys, welcome back to my channel once again. This is Talk with Ola. My name is Mujola Olua. The Ola is from the Mujola Olua, like I always say. Thank you so much for tuning in once again. If this is your first time, I really appreciate you stopping by. And if you're a returning viewer or a subscriber, thank you so much. I implore you to subscribe if you haven't. So I'm going to go into a few public service announcements before we talk about what we have to talk about today. So I have a few announcements. The first announcement is a vote of thanks to everyone that has supported this channel so far. It's been a very interesting journey. I'm so grateful that you have not allowed me to be talking into thin air, because you have given my speech an audience, and I'm really grateful for that. Thank you so much. I love you for loving Talk with Ola. Thank you so much. The second announcement is that one time someone left me feedback and said that they listen to Talk with Ola when they are doing their chores in the morning. So as they are doing their chores, they are listening to it. So they are not really watching the video, they're just listening to the audio. And so I just want to implore you, if you are someone that's always caught up, maybe too busy to sit down and watch the video, I just want to give you this idea that you could actually listen to it like a podcast, like audio recording. So that's where you get value and you can do other things on the go. You could probably be sweeping, washing plates, cooking even, or maybe even typing something or driving. You could listen to Talk with Ola like that, so that you can maximize your time and you don't miss out on the beautiful content that we have here. Like I always say, this channel is about laymen, law students and lawyers, and it's all about law and some more law. So there's something for everyone. Please do not go away. Please do not think that it's just for lawyers or for law students or for laymen alone. It's for all three sets or categories of people, and this is one way for you to maximize the value on this channel. You could listen to it like a podcast. Thank you so much to the person that actually gave me that feedback. So it's a very useful feedback, and I'm thankful for it. The third thing that I want to tell you about today is that I read a book. Yay! I've always been a writer anyway, so I read a book. It's on okadabooks.com. I'll leave a link to purchase it in the description box. It's just 1,200. So it's a collection of fictional stories, 10 stories in all. So they are very interesting stories, if I do say so myself, but I'd like you to please show me some love by buying the book on okadabooks.com through the link that will be in the description box. And if you know so much about publishing and you have ideas for me to scale and get the book to reach a wider audience, please don't hesitate to mail me at houseoflivingstones@gmail.com. I will welcome your suggestions and your advice and your counsel. Thank you. Now, the fourth thing is that I just wanted to remind you that I actually have a blog. I'm grateful for people that stop by my blog. Someone mailed me one time and said, oh, I found your Twitter, then I went to your YouTube, and then I went to your blog and all of that. So I just thought to remind you, if you do not know or you have not called your attention to it, that I actually have a blog. It's omlivingstones.wordpress.com. It's a personal blog. I've been blogging for 10 years, yes. So I just share personal things on the blog, and then I have a column for legal education, where I've shared my law school experience in 5 parts, where I've also shared, my opinion on some little research that I've done on, different aspects of law. So you can read it up. Then I have an opinion section where I talk about a lot of things. I have a hair section, I have a food section, I have a book review section where I review almost any book that I read that, I find worth reviewing. Yes, so I'd love for you to stop by my blog, Mujola Oluwa's blog, if you want to Google it, or if you want to check, there's a link to it in the description box. Please stop by my blog, read up some things. Some of the things that I talk about on the channel are things I've already written about on the blog in time past. So please stop by my blog. The fifth thing I want to talk about is my portfolio. I used to share the link in the description box, but I guess I got caught up and maybe I omitted to put it, so I will start putting it again. The portfolio is like a blog post that contains direct links to most of my published research and articles on law and law topics. I have a few on marketing, on digital marketing and stuff too, things that I've done basically, but also it contains most of my articles on aspects of law that caught my fancy in times past. So I continue to update it as I publish, especially things that I've published on other people's platforms, like some renowned and notable platforms. So please click the link to my portfolio to see what I've been up to in the legal space, as far as writing is concerned, you would find edification in these things, and that's why I'm calling your attention to it. Thank you so much. Now, the sixth and final public service announcement that I want to make today is that if you belong to a group, maybe a group of your friends, a large group, maybe a law student group or a law school group or a lawyers group, I want to implore you to please drop a link to any of the videos that you have watched and that benefited you. Please drop the links on these groups from time to time so that others can also benefit from what you have benefited from. It's very important. That's the way to push the message of Battle with Ola far and wide, and I really need you to join me in doing this. So please don't hesitate to share the link to the videos or the link to the channel itself, with your groups, especially WhatsApp groups, large groups, Telegram groups, and whatever and maybe give people a hint of what they are going to come and see on the channel, because it is for laymen, for law students, and for lawyers. And in addition, don't forget that if there's an area of law that you need help with, and that now I remember there are actually more announcements, so I'm going to go to the seventh one. The seventh one is that if there's an area of law that you need help or clarification with, or you want us to discuss, please feel free to contact me at houseoflivingstones@gmail.com. Talking about law is one of my favorite things to do in the world, so I'm never tired of it. I'm never fed up with it. Someone mailed me last week, and I was responding, doing research and responding to their email by around 2 a.m. and I had to go to work the next day. I'm just trying to tell you how important and how very enjoyable I find talking about law, writing about law, discussing law, spreading the legal message. So please, if there's an area of law you want clarification on, or you want us to discuss, or you want me to even make a video on the channel, just mail me at houseoflivingstones@gmail.com and state your case, or leave it as a comment on any of the videos, and I will get to it as soon as practicable and possible. The eighth and final announcement today is that a few people have messaged me asking me if I can tutor them for bar finals, and I have humbly declined, because I have a full-time job, so I can be very busy. I don't want to commit to something that I will not go all the way with. So I just want to encourage you that you have more than enough value to learn from on the channel. I believe that the things that we talk about they suffice in a way, in addition to what you're learning in law school. And I even created a playlist titled Law School, so that all the topics that are particularly related to law school curriculum come up under that playlist. So I want you to check it out, and I want you to be able to ask me questions. I've also told those people that if you have any questions, if you have things you want me to respond to, just message me. There are law school students that message me, do you have this draft, or can you talk to me about this? And I actually respond to them via email and the comment section. So please, let's do that for now. I do not really have the luxury of time because of personal work constraints now to actually tutor people one-on-one. So that is it. I apologize, and I hope that you continue to come on the channel and continue to learn as much as you can, to supplement what you're being taught in law school. I always say that whatever we talk about on this channel, law school, whatever they tell you in law school is the final. That's what you use for exams. So if you're in law school, I wish you success. I am looking forward to meeting you and seeing you at the bar. And now let's go into what we have to talk about today. Today we want to talk about a very important doctrine, the doctrine of Laches and Acquiescence. Let's go right into it. The doctrine of Laches and Acquiescence is an equitable doctrine, a doctrine in equity. Now, we have common law and then we have equity. Equity most times seeks to redress common law, or to give people relief where common law would have, worked hardship on them. So we have equity, then we have common law. But the doctrine of Laches and Acquiescence comes under equity, and is some sort of a defense for a defendant, in a civil suit. Now, let's explain it one after the other. There are some maxims that are interrelated with this doctrine, and they are delay defeats equity. That's an equitable maxim, which means that if you sleep on your right, you sleep in perpetuity. He who sleeps on his right sleeps in perpetuity. So the doctrine of Laches and Acquiescence comes into play this way. Let's talk about acquiescence first. Acquiescence, as an English word, means to acquiesce, to agree with something, to condone something, to in a way approve of something. That's acquiescence. So this doctrine means for instance, that if I find that someone has taken over my property and is using it, for their own purpose, wrongfully believing that it is theirs, and then I do nothing, I lead them on, I let them, persevere in their mistake, only for me to go to court later to now claim title to that property, the law will not aid me because of certain reasons that we're going to talk about. So the locus classicus for the Doctrine of Laches and Acquiescence, especially Acquiescence, is Ramsden and Dyson. It's an 1866 case, citation supplied. So in that case, the courts explain what acquiescence is. That is, if I have a plot of land and then I find that someone is building on that land, mistakenly believing that he is the rightful owner of the land, and I now have knowledge, adequate, actual notice of the fact that he's constructing something on the land, expending monies on the land, resources on the land, and I do nothing to stop him. I allow him to persevere in his mistake, and then afterwards I now go to court to assert my title and claim the land. The law will not aid me. The law will not aid me, and I will lose my title to that person because I had actual notice of their mistake. I let them on in their mistake, and they have expended resources, that can probably not be compensated for or returned, even if I wanted to return, or even if the court wanted to order a return. So that is the principle in Laches and Acquiescence. So if you have actual notice that someone is constructing on your land, for instance, I'm using land because it mostly comes up in land disputes, you cannot allow them to continue in their mistake. You give them notice immediately, I'm the owner of the land, and then let the fight start from there. Don't wait and say, let them construct their duplex, they are constructing it for me. It's different if you tell them and they insist and continue, than if you do not tell them and then you now go to court much later after they might have spent monies and resources constructing on the land, mistakenly thinking that they are the owner of the land. So now there are a few things that the court will consider before that defense can avail a defendant. That is, when you later go to court, they can come under the defense of Laches and Acquiescence, to actually claim the ownership of the property. But these are the things that they have to prove to the court, because this defense must be specifically pleaded. So they must prove to the court that they innocently and mistakenly believed that they were the owner of the land. Probably someone sold it to them, a wrongful seller sold it to them, and then they must show the court that they have actually expended resources, spent money, in constructing or in doing whatever it is they've done with the property or the land. Now, they have to also prove that you knew about it, and then that after knowing, you refuse to actually speak up or assert your title in good time. So they have to show that, to tell the court that, this person actually agreed with what we were, to show the court that this person actually agreed with what we were doing, because they did not come up, they did not raise an eyebrow, even though they knew that we were doing something on their property. So those are things that you need to prove to the court. So there are a plethora of cases, decided cases, that explain this principle, and I'll list them in the description box. But they are just to, and you see them on the screen as well, they are just explaining the fact that, this principle, this doctrine, this defense serves as an estoppel to someone who has led another person on to believe that a property that was not theirs, or that was was rightfully theirs. There's an element of fraud, and that's why the law will protect the defendant. Because if, for instance, now someone has gone on to construct a multi-million naira hotel on my land, and I waited and I did not say anything, even though I knew that I was the owner of the land, that's one. I knew that they were the wrongful claimant to the land, that is, they had no title to the land, that's two. I knew that they were building something on the land, expending resources, that's three. I also knew, that I had the right to actually stop them or put them on notice, but I did not, waiting for them, just so that I can set up a plea of, so that I can go to court much later and assert my title. That is fraudulent. So the courts will stop me from claiming title to that land, if they can prove, if all those things can be proven before the court. Now let's jump to laches. Laches means delay, Yes, we say acquiescence means agreeing. Laches is delay. So both of them are usually played together. So laches and acquiescence. So laches is delay. That is, you delay from exercising your right over something that you have lawful claims to. And as such, you have created some sort of waiver of those rights. And you have made the person who does not actually have rights to them to believe that they actually have rights to them. So the court will stop you from claiming those rights much later. Delay defeats equity, and he who sleeps on his right sleeps in perpetuity. Laches can be used in court by a defendant to show the court that you waited too long. There need not be an element of fraud in this one, but that you waited too long, that they had rightfully and justifiably understood that waiting to be a waiver of your rights over whatever it is you're disputing over. So do you understand? It means that you have led the defense on by your standing by, your inaction. You have made them believe that you are not going to exercise that right. So if you are coming up much later to exercise the right, the court will be reluctant to actually, accord you, the honor or the right, because the court will ask the question, why did you delay? So your delay might be a waiver of your right. Delay defeats equity, like I have said. So, but it's not in all cases of delay that, the court will interpret it as a waiver. If you're able to prove to the court that the delay was, out of your hands. For instance, if someone has fallen ill, you saw that they were building on your land, but before you could take any action, you fell ill. Maybe you fell ill for 2-3 years, or maybe the person went into insanity, or maybe, something else happened that made it impossible for that person to actually claim their rights or exercise, their rights over whatever is the subject matter of the dispute. If you're able to successfully prove that to the court, the doctrine of laches, will not avail the defendant. So it's not in all cases of delay, and the delay need not to be fraudulent in the case of laches. But in the case of acquiescence, it has to have been fraudulent, and you must have come across to the defendant and to any reasonable person as an agreement, with them that they should be the owner of the property or the rightful claimant, to such rights that you stood by and refused to exercise. So that is the doctrine of laches and acquiescence. There's a plethora of cases on this, like I said, and it cuts across different types of civil matters. So you can read up Gidado and Lawal, you can read up Badamosi and Dairo, you can read up Okereke and Nwankwo, you can read up Taylor and Kingsway Store. So many cases to explain the doctrine, the defense of laches and acquiescence. And particularly for laches, you can read up Lindsay and Orad. It's an 1874 case. That's the locus classicus for laches, just like Ramsden and Dyson is the locus classicus for acquiescence. But both are usually played together, and those are the things that you have to prove to the court, like I've explained. Also note that this defense follows the law. You know that equity follows the law. So if there's a limitation period for the action under normal circumstances, I talked about limitation period in the video that I did on preliminary objections. So if there's a limitation period, that is a period within which you have to bring an action on the dispute, else it's statute bad. If there's such period, you cannot bring up the defense of laches and acquiescence. That one, the defense will not come up at all. It only applies where there's no limitation period for the action. If there's a limitation period, the limitation period will ordinarily apply. Now, something else to note is that if the plaintiff, that is the claimant, the rightful owner, the person that has rightful claims to whatever it is you're disputing over, did not know of his rightful claim, the defense will not avail you as a defendant. So if you have built on someone's property and maybe 10 years later they are showing up and say and there's no limitation period for that action, and they're now saying that, oh, it's my land, and they did not know at that time that it was their land, for instance, maybe it was willed to them, gifted to them, or maybe for some reason they did not really know of that right at that time, that defense of laches and acquiescence will not avail you as a defendant. The flip side is that you as a defendant, if maybe you were informed by a third party and then you waved it off and said, are you the owner? You're not the rightful owner, so I'll continue. The defense will not avail you because that's an element of fraud. because there's an element of fraud there. So what I'm saying is that if as a defendant you knew or you came to the knowledge of the rightful owner, yet you continue to exercise that right wrongfully, you continue to build the house, for instance, wrongfully, after you had been put on notice that, oh, this is the person that owns the land, even if it's not the person that has challenged you or come to you directly, the defense will not avail you, because now we need to start talking about fraud, and malice. A maxim of equity that comes in handy here is that he who comes to equity must come with clean hands. So if you're trying to bring a defense of laches and acquiescence, you have to come with clean hands too. There must be no fraud on your part, as there must be no fraud on the other person's part as well. So that is how to claim, laches and acquiescence over a property. You prove all those things we talked about to the court, and if successfully proven to the satisfaction of the court, that civil suits are on a preponderance of evidence, that is on a balance of probabilities. So if you weigh higher on the scale of probabilities, the court will grant you what you asked, and then the right or the title will successfully move over to you. You will become the rightful owner of such property. The title will be vested in you, and the claimant will lose their title because of the things you've been able to successfully prove against them. So you can read up more on this, but that's essentially what laches and acquiescence means. Delay defeats equity, and he who sleeps on his right sleeps in perpetuity. But also equity follows the law, and he who comes to equity must come with clean hands. That's all I have for you in this video. I will see you in my very next video. Toodles.